All right, now we're on to the second section for part 2 of the history of forensic science, which is chapter 1 in your textbook. And this discusses the rise in the number of crime labs. So to start out, in 1973, Nelson Rockefeller enacted a zero tolerance for drug sellers and users. And the sentence was 15 years to life for drug dealers and addicts. Very, very strict. So you can see the graph here shows the prison population between 1925 and 1971. And then in 1973, the war on drugs with all these very strict laws happened. And you can see that the prison population just has escalated between the last 40 years. The U.S. state and federal prison population has increased over 800% in the last 40 years. I'm not going to show this video. You can look at it on the slide deck if you'd like. It talks about the Rockefeller drug laws and how they have impacted the prisons. All right. So major reasons for the increase in the number of crime laboratories, which is what the question that we're trying to answer in the first place. The Supreme Court decisions, and first of all, with the tough drug laws, right? They needed more labs to process the people that they wanted to put in jail for drug issues. Secondly, the Supreme Court decisions in 1960s responsible for police placing greater emphasis on scientifically evaluated evidence also was a reason to increase the number of crime labs. And they determined that a successful solution of the crime will depend on the discovery and analysis of physical clues, not just eyewitness testimony. Clearance rates of offenses with scientifically evaluated evidence was approximately 3 times greater than when scientific evidence was not used. Crime laboratories are inundated with drug specimens due to the changes in the drug laws in the 70s. There was over a 4-fold increase in drug-related crime since the early 1970s. The opioid epidemic has resulted in a large increase in drug samples submitted to crime labs also. That's a little bit more recent than the 70s. Expanding the role of forensic science. Another major reason for the increase in the number of crime laboratories is the advent of DNA technology and profiling. So everything gets swabbed for DNA, and so all of those DNA samples have to be processed. Relatively new in New York, there's a rape kit legislation that requires rape kits be processed within 90 days of receipt, and the results submitted to the agency and the local district attorney, all within that 90 days. So this is the bill number, and this is the legislation number. But that happened in 2016. So there's a lot of emphasis on DNA testing. Historically, law enforcement was based on eyewitness testimony and only rarely included the presentation of physical evidence. But juries now expect physical evidence to back up storylines, and civil protections for the accused have become very well understood by the public, which is good, I think. So questions that you need to answer: what are the Rockefeller drug laws? They're very important in the history of criminology. Number 6, what is a reason that the number of crime labs have increased? All right, the last section, and this is also very important, and it's something that you pretty much just have to memorize: important court cases. So some of the court cases that have shaped forensics and the judicial system are below, and we're going to talk about those in a little more detail. So Mapp versus Ohio in 1961, the police asked to search this person's home. Her last name is Mapp, Dolores, I think is the first name. They refused the search and she requested a warrant. The police faked a warrant and searched her home anyway. And they found sexually explicit material that they used to put Dalree Mapp in jail for 1 to 7 years. Oops, sorry, I don't have a picture there. There's her picture. The Supreme Court ruled against the police, saying that it was an unreasonable search and seizure and there was no probable cause because they faked the warrant. So now the police have to have a warrant in order to be able to search your home. Gideon versus Wainwright in 1961, there was a crime at 8 a.m. where somebody broke down the door and smashed a cigarette machine and broke the record player and stole money from the register. Eyewitnesses states that Gideon was in the pool room around 5:30 that morning. And Mr. Gideon had wanted a lawyer to help him with his case, and the court said, Mr. Gideon, I am sorry, but I cannot appoint counsel to represent you in this case under the laws of the state of Florida. The only time the court can appoint counsel to represent a defendant is when that person is charged with a capital offense. I'm sorry, but I will have to deny your request to appoint counsel to defend you in this case. Gideon says that the United States Supreme Court says I am entitled to be represented by counsel. He was found guilty and sentenced to 5 years in prison. He wrote to the Supreme Court and was given a new trial with a court-appointed attorney and found innocent. The court ruled that all citizens must be provided a lawyer if they cannot afford one. So that was the final ruling. Gideon versus Wainwright. And the third case that we are going to have here is the Miranda versus Arizona, where the court ruled that citizens must be informed of their rights prior to questioning. You guys all know the Miranda rights, right? This person, Miranda, gave a confession after a long interrogation. Any evidence or statement obtained prior to a suspect being read his or her rights is inadmissible. This has led to what is commonly referred to as one's Miranda rights, having to be read upon questioning or arrest. And there are many cases where those rights may have been read to the person, but not really respected. Another very important case is the Frye standard. So in Frye versus the United States in 1923 was about the admissibility of a lie detector method based on measurement of blood pressure. The decision set guidelines for determining the admissibility of scientific evidence into the courtroom. To meet the Frye standard, the evidence in question must be, quote unquote, generally accepted by the relevant scientific community. Another big case for admissibility of evidence is Daubert versus Merrill Dow Pharmaceuticals. In 1993, the lawsuit over a drug to treat severe morning sickness was, taken up. So the U.S. Supreme Court asserted that the Frye standard is not an absolute prerequisite to the admissibility of the scientific evidence. And I just repeated what Frye standard is below. Trial judges were said to be ultimately responsible as gatekeepers for the admissibility and validity of scientific evidence presented in their courts, as well as all expert testimony. So they can look at whether the technique can be tested, what is the potential error rate, general accepted within the relevant scientific community, which was the Frye standard question. Are the standards and controls for the scientific method? Has the theory or technique been subject to peer review and publication? So all those questions should be answered if the trial judge is going to accept the evidence. As you know, the scientific method is to formulate a question worthy of investigation, formulate a reasonable hypothesis to answer the question, test the hypothesis through experimentation. And by experimentation, it doesn't mean just do it once. You know, something has to be done over and over under different circumstances. And usually in science, different people have to do the test to make sure it's not a fluke. And upon validation of the hypothesis, it becomes suitable as scientific evidence. Okay, so continuing with questions. Police walk into your yard and suspect that you have illegal material in your home. They search your home and find 3 grams of cocaine. What court ruling protects you? 3 major factors that increase the number of criminal cases include population growth, changes in technology, and what? Number 9, what is the reason that in New York State sexual offense evidence kits must be processed within 90 days? The following questions are fill in the blank. 4 important federal agencies offering forensic services are the ATF, the DEA, the U.S. Postal Inspection Service, and what other federal agency? Number 11, the examination of blood, hairs, fiber, and botanical material is conducted in the what unit of the crime lab? Examination of bullets, cartridge cases, shotgun shells, and ammunition of all types is the responsibility of what unit? The examination of body fluids and organs for drugs and poisons is a function of the something unit. And a person is a person who can demonstrate a particular skill or has knowledge in a trade or profession that will help the court determine the truth of the matter at issue. So who does that? What is the name of that role? The following questions are, I'd like you to determine which crime lab each piece of evidence should be submitted to. Your choices are criminalistics, biology, firearms, document examination, toxicology, latent fingerprint, anthropology, and forensic computer and digital analysis units. So if you just go through this, you pick the correct one. That's it for the rest of chapter 1.